So most merger cases tend to settle after the grant of a preliminary injunction. Doesn't this counsel in favor of having a bench trial on the merits at the same time? Wouldn't that suggest that we ought to have that? In other words, if the answer is no, because the parties sometimes prevail in later litigation on the merits, isn't this an even stronger reason to ensure that the preliminary injunction and merits are litigated at the same time? So some of the same arguments you're using, one of the arguments you're using here is that you haven't used this authority in 20 years. It rarely arises. And so why worry about it? Well, I do worry about it because of the fact that if in practical effect, most of the time you have one bite at the apple anyway. And in your case, in the case of something that's before under the jurisdiction of the FTC, if the bite at the apple tends to be at the preliminary injunction phase, then why not have the more fulsome type of review that you have when you have a whole review on the merits? Why not have that all at once? And so I'm sympathetic to the view in this and in every other area of the law that we don't want to adopt things that are solutions in search of problems. But I think the same criticism can be made of the existing provision of law. If the existing provision of law is itself a solution in search of a problem, then why not make the two standards the same? Why not put people through the same process?
Mr. Chairman, I would argue that the parties can, under our current system, what they can do is that they can stipulate to a preliminary injunction, which is something that we seek in order for us to enable us to obtain meaningful relief at the conclusion of a merits trial. So the parties could very easily stipulate to not consummate the particular merger or to robust hold separate, and then proceed to a merits trial. And there you would then be before the commission, and you would go through the merits trial before a commission and then obviate a step before a federal court. So that is a process that if parties so choose, that is available to them. So I would argue that that's another route that one can take, and one need not alter the existing system in order to allow for that, to address the concerns that you've expressed.
And yet that doesn't happen in this context, at least not with the same regularity that it happens when
parties actually know that. Apologies for interrupting you, but it actually does occur on occasion.
With the same regularity?
On occasion. We're speaking about already a very small number of matters. In the RDOC case, that was a situation where there was a stipulation, and then it proceeded to merits trial. Ultimately, that was resolved via settlement. But again, we are speaking just as an initial matter about a very small universe of cases, and so the numbers are not large.
Now, I want to make sure I understand your position correctly. Do you believe there is no difference between the preliminary injunction standard prescribed for the FTC under Section 13B of the FTC Act and the one that applies to the DOJ?
There's no question that the standards are worded differently. They're different language that's used under the authority that we exercise.
But in my
view, in effect, courts, I believe, district courts take their role very seriously. They absolutely understand the importance of this preliminary injunction phase. I think we see that evidenced by the two most recent matters in which we have sought a preliminary injunction. The Cisco matter, in which we prevailed and did get a grant of an injunction. The court wrote this incredibly detailed 140-page opinion that was thorough, careful. Courts undertake this role very seriously, and I believe that they end up applying the same standard that ends up applying when the Department of Justice seeks a preliminary injunction.
So if they are in effect the same, if they have the same practical effect, why not have them also be the same?
So ultimately, in the abstract, I have no issue with harmonizing the preliminary injunction standards. My fear and my concern, again, and I say this with 20 years of litigation experience and in my experience of more than several years as a law enforcer with the Commission, my fear is that a change in the standard, given that right now it is the same standard as the Department of Justice, my fear is that courts would then not understand the purpose of the change and perhaps end up imposing either a higher standard or just simply would create uncertainty as to what exactly the new standard ought to be. So I think that creates uncertainty, but in theory, in harmonization of the standards I don't see as a problem. I believe they are already de facto similar standards effectively. Okay,
I think I understand your position there. I struggle with it just the same because if I'm understanding you correctly, you're saying we've got two different standards, but they're interpreted the same way by courts. If we make the standards as they're written into the law literally the same, then the courts might make them different. I do struggle with that.
Senator, my point is simply that I don't believe there's a need to make a change here. My worry is that with any change, attorneys who zealously advocate for their clients and parties who, look for any argument that they want to make, I just fear needless litigation over issues about what the standard might mean if there is a change, given that in my mind it's being applied appropriately today. So why make a change? Furthermore, I also, of course, this particular bill goes far beyond that and then addresses, again, the adjudicative authority that we have. And so my concerns extend beyond simply a harmonization of the PI standard.
What would you say, responding to my concern, that the courts, I mean, as a matter of canons of statutory construction, tell judges that they're not supposed to assume that differences in legislative language are irrelevant. They're not supposed to just lightly ignore surplus or minor differences. I mean, I think I could, if what you're worried about is consistency in the application of the law, I could make a corresponding argument to yours that would say the greater risk is that at some point courts are going to realize, hey, these aren't the same standard. There must be a difference, and that could change that way. We, of course, don't have control over what the courts do, but we do have control over what the law says. And if what you're telling me is that the law ought to provide for the same substantive standard, the same standard in effect, I do struggle with the idea that we should not change the law to make sure that the law actually says the same thing in these two areas. Do you want to respond to that?
Senator, let me just take issue with the way that you've constructed your comment. The courts aren't comparing the FTC standard as compared to the Department of Justice standard. And let me also just state that the standard that's applied, of course, with the Department of Justice is just the traditional preliminary injunction standard that's in the common law that is articulated by courts. But they aren't comparing the language that's in the FTC Act as compared to that traditional standard. So I think there's your point about statutory construction, I don't believe is apposite to the way courts approach this issue. If you look, again, I would urge the members of the committee to look closely at the way that the courts in the Cisco matter, the decision in June and also the recent decision in the Steris case, see how those courts apply the standard and compare that to the way courts have applied the standard in Department of Justice cases. You will see that there is that same requirement that the FTC establish a likelihood of success on the merits. And again, in my mind, the way the standards are articulated end up no differently. And the outcomes, in my mind, are also not determinative, depending on who it is that you're in front of.
So harm could come from additional efforts at statutory clarity.
I'm sorry?
We attempt to clarify the standard. Harm could come from that. That's your concern.
That is a worry, but more fundamentally, my concerns go beyond the issue of harmonization of the PI standard. My major concern about this proposed legislation is is with regard to the effort to eliminate the administrative process. That's the fundamental concern.
Got it. Thank you. Senator Klobuchar.
Thank you.